Hello and welcome. I am Juliet Rizzo and I will be talking with Larry Ringer and Susan Falkenhand from the Office of Special Education Programs, or OSEP, about the final Part B regulations implementing the Individuals with Disabilities Education Act, or IDEA. We'll be talking about the provisions relating to evaluations, reevaluation, and individualized education programs, or IEPs. Welcome, Larry and Susan, and thanks for being with us today.
Hi, Julia.
Hi, Juliet.
We have a lot of information to cover on these topics today. Since an evaluation takes place before a child can be found to be a child with a disability and thus eligible for an IEP, let's talk about that first. What has changed in this area?
Let's talk about parental consent first. The basic provision is very similar to that in the prior regulations, with some clarifications. For example, what if a parent does not provide consent or respond to a request for consent for an initial evaluation? In that case, the public agency may, but is not required to, pursue an initial evaluation by using Part B's procedural safeguards, that is, due process hearing and/or mediation.
There's a new provision that if a public agency chooses not to pursue the initial evaluation in this situation, the child find requirements to locate, identify, and evaluate the child are not violated.
That's right, Susan. And there's also a new provision regarding children who are wards of the state and not living with their parents. The public agency is not required to obtain informed parental consent for initial evaluation if the public agency cannot find the parents.
After making reasonable efforts to find them.
Right, or if the parents' rights are terminated under state law, or if a judge appoints an individual to represent the child.
There's also a new provision for parents whose children are homeschooled or placed in a private school by the parents at their own expense.
That's right, Susan. In these cases, the public agency may not use procedural safeguards to override the parent's lack of consent or failure to respond to a request for consent for an initial evaluation of the child.
And the public agency is not required to consider the child eligible for services under the Part B provisions regarding children placed in private schools by their parents.
As you said earlier, it seems more like clarifications than changes. The main requirement to obtain parental consent before initial evaluation is still in place. Are there revisions regarding reevaluations?
They mirror the changes to the consent override provisions. If a parent does not consent to a reevaluation, public agencies may, but are not required, to pursue reevaluations by using the procedural safeguards. However, if a parent fails to respond to a request for consent to reevaluate his or her child, the public agency may, but is not required to, conduct the reevaluation if it can demonstrate that it made reasonable efforts to obtain consent and the parent failed to respond. And in both cases, the public agency does not violate obligations under child find and evaluation and reevaluation provisions if it declines to pursue the reevaluation.
I understand that IDEA 2004 provides timelines for completing initial evaluations. This is a completely new provision, isn't it? What are the timelines?
Basically, the regulations replicate the statute in this area. An initial evaluation must be conducted within 60 calendar days of receiving parental consent for the evaluation, or if the state has established its own time frame, within that time frame.
So states have flexibility regarding these timelines.
Yes, up to a point. The 60-day timeline applies unless the state has a state-established timeline.
And there are two situations where the time frame does not apply. One such situation would be if the parent repeatedly fails or refuses to produce the child for evaluation. Another would be if the child enrolls in a school in another public agency after the time frame has begun, but before the determination of eligibility by the child's original public agency.
And there's a caveat to that second provision. The exception to the time frame only applies if the subsequent public agency is making progress to ensure prompt completion of the evaluation, and the parent and the subsequent public agency agree to a specific time when the evaluation will be completed.
The timeline provisions have a major effect on how public agencies will conduct business, don't they?
We think they balance the requirement to locate, identify, and evaluate children with disabilities in a timely fashion with the realities of day-to-day business in schools. Children transfer to a school in another public agency. Parents may be reluctant for their children to be evaluated. Essentially, the time frame and the exceptions to the time frame are intended to ensure that children with disabilities are identified in a timely fashion and that public agencies keep track of children who are being evaluated.
So let's move to the IEP. There are some major changes around the IEP process, aren't there?
There are several new provisions. We'll try to walk through them step by step.
I think the excusal provision that allows some IEP team members to not attend the IEP meeting is a significant change.
How can an IEP team participant be excused from participating?
If the IEP team member's curriculum area or related services area is not being modified or discussed, that person is not required to attend the IEP meeting in whole or in part if the parent and the public agency agree in writing that attendance is not necessary.
Is this true for any member of the IEP team?
That was possible under the draft regulations, but in response to several public comments requesting clarification, the final regulations make it clear that this applies only to the special education teacher or provider, the regular education teacher if the child is participating in the regular education environment, the public agency representative, and the individual who interprets instructional implications of evaluation results.
What happens if an IEP team member asks to be excused and that member's curriculum or related services area is going to be discussed or modified at the meeting?
That team member may be excused in whole or in part if the parent and the public agency consent to the excusal in writing,
And the team member submits in writing input into the development of the IEP to the parent and the IEP team prior to the meeting. There are also changes in how IEPs can be amended. If the parent and the public agency agree, the IEP may be amended without convening an IEP team meeting. Instead, the IEP team may develop a written document to amend or modify the IEP.
So the annual IEP meeting is still required.
yes, this provision applies to changes or modifications that need to be made after the annual IEP meeting is held, but before the next scheduled review of the IEP.
It's important to note, however, that if changes are made to the IEP without an IEP meeting, the public agency must ensure that the child's IEP team is informed of the changes.
And a parent can request at any time a copy of the IEP with the changes incorporated.
That's helpful, and I'm sure parents will appreciate the effort being made to make the process more flexible and responsive. Are there any other significant changes you'd like to mention today?
I think both parents and practitioners need to be aware of a few changes regarding the contents of the IEP. Under previous law, the IEP had to include a statement of the child's present levels of educational performance. Under the new regulations, the IEP must include a statement of the child's present levels of academic achievement and functional performance.
Similarly, the IEP must include a statement of appropriate accommodations necessary to measure the academic achievement and functional performance of the child on state and district-wide assessments.
Speaking of assessments, that reminds me that IEPs must now include benchmarks or short-term objectives only for children with disabilities who take alternate assessments aligned to alternate achievement standards.
So not all children with disabilities will have benchmarks or short-term objectives in their IEPs.
That's right, Juliet. The focus is on accomplishing the annual goals.
The requirements around addressing the alternate assessment in the IEP have shifted somewhat as well. Under the previous regulations, if the IEP team determined that a child would not participate in a particular state or district-wide assessment of student achievement or part of an assessment, the IEP had to include a statement of why that assessment was not appropriate for the child and how the child would be assessed.
Under the new regulations, if the IEP team determines that the child must take an alternate assessment instead of a particular regular state or district-wide assessment of student achievement, the IEP must include a statement of why the child cannot participate in the regular assessment and why the alternate assessment selected is appropriate for the child.
So the regulations now are looking for the reasons for choosing an alternate assessment more than just how the assessment would be done.
That's correct. And another major change in IEP content is around the secondary transition requirements. Before IDEA was amended in 2004, each IEP had to include, for each student with a disability beginning at age 14, a statement of secondary transition service needs.
So when and how do children with disabilities participate in transition planning and receive transition services?
The regulations, mirroring IDEA 2004, state that transition-related goals and services must be included in the IEP no later than the first IEP to be in effect when the student turns 16.
But the regulations continue to state that transition-related goals and services can be included at a younger age if the IEP team determines that it is appropriate and must be updated annually. Larry, say a little bit about what the IEP must address with respect to transition services and goals. The regulations are only one paragraph, but there's a lot in that paragraph.
Sure, Susan, I agree there's a lot there. The transition content must include appropriate measurable post-secondary goals based upon age-appropriate transition assessments related to training, education, employment, and where appropriate, independent living skills, and the transition services including courses of study needed to assist the student in reaching those goals.
That is a lot of information to include. If I'm not mistaken, the prior regulations did not include the age-appropriate transition assessments.
You're right, Juliet. That's a new provision. Another new provision concerns children with disabilities who have IEPs and transfer from one LEA to another within the same state and between states. Susan, you've handled some questions about transfers. Can you explain the new requirements?
I'd be happy to do that. I think the regulations and the statute have incorporated ideas that OSEP has been supporting for some time. I think it will help parents and schools ensure that children with disabilities don't lose services when they transfer schools. Briefly, when a child with an IEP transfers within the same state, within the same school year, the new school, in consultation with the parents, must provide a free appropriate public education, or FAPE, to the child. This includes services comparable to those in the child's IEP from the previous public agency. Those services must be provided until the new public agency either adopts the previous IEP or develops, adopts, and implements a new IEP that meets the applicable requirements.
What happens when a child with an IEP transfers from one state to another?
The requirement to provide FAPE is the same. Those services must be provided until the new public agency conducts a new evaluation, if determined necessary by the new public agency, and develops, adopts, and implements a new IEP that meets the applicable requirements.
And whether the child transfers within the state or between states, the regulations require that both public agencies take reasonable steps to ensure that the child's records, including the IEP and supporting documents, are transmitted promptly to the new public agency.
It sounds like there are a number of changes around evaluations, reevaluations, and IEPs. Some are fine-tuning, and some are significant.
I think that's right, Juliet. We encourage everyone with an interest in special education in general or a specific child's IEP to become familiar with the new regulations. There is information on our website at idea.ed.gov and information in the curriculum that will be completed by January 2007. The Q&A corner on the website will allow anyone to submit questions regarding these changes.
Thanks, Larry and Susan, for taking time to talk with us today about these regulations.
Thanks, Juliet,
Thanks,
for
Juliet.
having us here.
This video is one in a series prepared by the U.S. Department of Education, Office of Special Education Programs, to assist our stakeholders in better understanding some of the significant provisions of the final regulations implementing IDEA 2004. We hope you found it helpful, and we thank you for your attention.